to another edition of Gov Tech Today. I'm Russell Lowery.
And I'm Jen Saha.
And together we try and bridge the gap between .com and .gov. On today's episode, we're going to talk about an issue that kind of exploded onto our plates seemingly out of nowhere. But we got a decision that essentially prohibited non-compete clauses. For us California folks, I know we've mostly ignored them because they've been treated as largely unenforceable in California for a lot of transactions. But why don't you kind of set the table for us? What happened? What was the ruling, and where do we stand?
So it's sort of estimated that maybe around a quarter of worker agreements include a non-compete clause in them. So it does have a pretty widespread impact. Again, California, they've been unenforceable for a long time. Our Attorney General has reminded people of that, told them he highly discourages use of them in contracts because of that California non-compete, non-enforceable type of outlaying. But nationally, it's a big deal. And the FTC ruling just recently bans almost all non-competes. There's a couple exceptions in there for really high-ranking executives at companies, but basically it means you cannot enforce a non-compete agreement, even an existing one in a contract. So it doesn't explicitly bar employers from instituting non-disclosure agreements or non-solicitation agreements, or even non-solicit, where you would take your clients or your CRM database and download it to your thumb drive and take it to your next employer. But we're heading the direction, and personally I think it's a positive one, of getting rid of non-competes altogether.
Well, not surprisingly, the day after the decision was released, litigation was filed to put a stop to it, and people have built their business. And I'm happy to take the other side of it. But Ryan was the company that a tax advocacy firm was the firm that supplied the lawsuit, that filed the lawsuit, and just without regard to them specifically, a company spends a lot of money to acquire customers, and they hire employees to build a relationship with those customers. And having an employment agreement that says, I'm not investing all of this money into procuring the client, and then you can just leave and take a book of business with you that only exists because I invested in the means to do that. And then as you built that relationship, you decide to just take the cream off the top. That would be a disaster for certain business models, and it seems fundamentally unfair to the person that built the existing business. And that's what that voluntary agreement between an employer and employee is meant to protect. So I can understand the litigation. I would have built my business differently. The FTC coming out of nowhere with questionable authority to issue a ruling seems unfair. I would have built my business differently. I built it based on the rules in place.
It certainly maybe should have been done legislatively as opposed to this rulemaking outside of what I think would probably normally be recognized in legislation. So the counter argument there is, if I'm taking what's in my head, which is what this allows, I can't take, patents and plans and all of that. I'm literally only just have what's in my head. And if I take it to a new employer, they're going to have to develop all of that themselves and really invest the money to develop it, as opposed to my previous employer was already in some type of development on it.
Well, in the case of in the case of Ryan, and I'm fine to talk about them because they did file the litigation and it's been a big deal. It's not just the information that was in your head. In order for any kind of consulting business, there's the ability to do the consulting and the ability to do the client, to get the client in the first place. And so if Ryan's expertise as a tax firm and their reach across multiple states and their ability to pay and attract top quality talent all makes that an attractive place for customers to come. And then they meet someone who in that environment, the client meets someone in that environment who's a rock star, who's really good at what they do. The information in their head is first class. That rock star person may have acquired all of that knowledge because I paid them to learn it. They also acquired all the relationships because I paid for them to have it. And now that that whole thing is together, that whole picture is complete, I'm now able to profit on it. And instead of profiting on it, you're just going to take what I built and open up a shop over here, take everything that I built, and you take the cream off the top. My employment agreement is designed to keep that from happening. And you knew what that was when you started. Like that's the deal. And setting that up, clients are free to leave, but you don't get to take my talent and the expertise that I poured into this person with you. You get to leave, go to another firm, go to another individual. I would have done things or structured things differently. If I was going to kind of explain some of the negative, unfair, if I had to, I would have designed my business differently to protect myself from that. If that was the law or the rule. But the bad part for the customer is, okay, so I'm not going to have anyone working on one of my clients for more than 3 months at a time because I don't want anyone developing a relationship with the customer where they could walk. Or I'm going to invest less in my people so that they don't have the full picture. So I want really specialized people, and they need 4 different experts to handle my problem instead of one in order to get their problem solved. And instead of anybody having the full picture or being able to service their needs, I'm going to design my business in another way. All of that could just make the provision of services more expensive for the end user than what the FTC is envisioning.
Yeah, I mean, it is a good point. So the FTC is anticipating that this is going to create 8,500 new businesses per year. And that's your skilled employee with all of that incredible knowledge breaking off on their own and starting their own thing and taking a portion of, the previous employer's business along with them. So I do think it ultimately will result in more competition in these industries, maybe competition from your previous employees as that goes. And I think it really will encourage people to be more protective moving forward, right? Retrospectively, you're right. You're stuck. Like, this is how you built your business today. But moving forward, I see a lot more companies paying special attention to defining something as a trade secret, or enforcing trade secret and IP laws. If I'm an attorney working in IP, I'm like, yay, this is my paycheck for the next, 10 years when this goes into effect, because a lot of that is going to be up for litigation at this point. Another case that someone raised to me that I think is very applicable here and could be problematic is in the investment industry. So if I'm, Merrill Lynch and I have a rock star trader on my team and he goes to Goldman Sachs, takes all of that expert trading information and really specific information about strategies and stocks and everything that's proprietary, and then, applies that same exact strategy over at Goldman Sachs, it's a way of leveling the playing field, but at the detriment of the guys that were ahead of it, right?
Right. And I think what I worry if this were fully enforced, I don't expect it to be fully enforced, because I think there's rights inherent in what you've developed that and those relationships that you've developed that I suspect the court's going to protect. But not being a lawyer and deferring to some of that, I think what you're going to see is an explosion of litigation and expense and protecting that client relationship. That could ultimately be worse for consumers. It'd be one of those responses to regulation of unintended consequence where we wind up getting more expensive, lower quality service, for some benefit for those people who are free to leave. They definitely, some people will profit from it. But I think largely at the expense of people who are going to be in the environments with the firms who are going to have to adjust their business practices in order to protect their business.
Definitely will be highly litigated. And certainly, I think there's still a lot to be determined on this. And I do agree that maybe this should have gone about coming into being an actual rule in a different way,
Right.
one that would have given more insight into it and more public disclosure and
Right.
deliberation. So definitely caught me and probably everybody off guard. Being based in California and being a California company, they're already not enforceable, but I've seen them in plenty of contracts. And,
Sure.
I think just being in California and knowing that they aren't enforceable doesn't stop people from putting them in there because, they just want you to know they're serious about this and
Right.
they will go after you if you take anything. I think to the worker, what this means is if you had one of these in your contract or you're looking at a contract that has one of these, just know that there's no teeth behind it anymore.
Right.
But what I also think it means is that you have the freedom to move around and take your innovations wherever they may go. You still need to be careful. You can't, download the company's entire share drive and
Right.
take it with you to the next guy or, print out a list of all of your clients and take that and start calling them. But I think ultimately, it's kind of a nothing burger for us in California because we haven't had to comply with these in the past. But for everyone else, it's going to be a bit of an adjustment.
I think when we think of things, especially on our podcast, we tend to think of the tech community first, and that's top of mind. And tech is notorious for poaching bright people, really smart people, buying up products and lines and that kind of shifting. I think where the unenforceable and a subtext for litigation is really in the small business environment. If you are a CPA and you're working in a CPA firm and you go hang your shingle and you try and do the tax returns for the same people you did before, but under another shingle, you are going to get sued, and or you would have at least before the FTC. It would have been an expensive nightmare. It's a primary consideration for small businesses. I've bought one. And I've been involved in a couple different transactions. It's a primary consideration when you're going to buy another business that they have relationships and contracts and clients that are really valuable. That's part of the value of the business. And I'm sure the FTC didn't have these people in mind, but your business is way less valuable if I have the threat that you could call all of your previous customers and all your previous contractors and open up the same business across the street the day after I buy it you have made my business a lot less valuable immediately
Totally.
if that is the case. But if I can work with a willing buyer and seller and come up with a non-compete, they're able to get the business that they want to buy, and I'm able to get a price that I'm that I'm willing to live with. Then that seems that system worked for small business transaction world, and by small business I mean we're talking $10 million and less type of businesses. But most employees work in that small business environment, and this could have unintended consequences that may not have been there if people had the big tech businesses in mind. But we'll see how it plays out over the coming months.
Yeah, I think if you're an employee, you've overnight become more marketable based on the knowledge and experience that you have. This could lead to bidding wars for really knowledgeable employees. If you're one of those employees, awesome for you. The downside is on the employer. And, what should employers do like overnight to sort of try to mitigate some of the risks with this? Make sure those non disclosure agreements are airtight with your employees, and make sure you're classifying trade secrets appropriately so that those cannot go somewhere else with your employees. And honestly, treat your employees so great that they never want to leave, even if someone does throw something really enticing at them.
That's a good point. It's always good to treat your employees well. And I'm always skeptical of anything that somehow giving lawyers more work to do is going to make things better. But I can definitely see how a talented employee and a bidding war for talent could be good for some of those employees.